As you all know, Homeland Security recently updated the law and defined what it means to be a public charge. And if you're an immigrant, if you are not a US citizen, it is important that you know how this change impacts your immigration status and what you may be eligible for in the future. This law has been in effect for many, many years, but just now in August of 2019, Homeland Security decided that it was time to publish a final rule with all of the updates that they've made because there was some ambiguity in the old law. What you need to know are three things. Number one, this new law punishes immigrants for seeking public benefits. Number two, they have more clarity and define what it means to be a public charge. And number three, they have a new standard called Totality of the Circumstances, which is going to weigh all of the positive and the negative factors to determine if you're a public charge. So what does it mean to be a public charge? If you are not a US citizen and you've received one or more public benefits for 12 months within a 3-year window, then you will be considered a public charge and you will not be eligible for the immigration benefit that you're seeking. The term public benefit includes Social Security income, TAMF, which is the temporary assistance for needy families, SNAP, which is a supplemental nutrition assistance program where you get a debit card and the government puts money on your debit card so you can go to the grocery store and get groceries for your family, most forms of Medicaid, and Section 8 housing. So I listed about 5 right now, and you need to understand that if you've received that type of public benefit, again, for 12 months within a 3-year window, then you will be deemed a public charge. Are there benefits that you've received that don't necessarily apply under the new law? And the answer is yes. That includes some of the following Medicaid benefits. For example, if you receive treatment for an emergency medical condition, if you receive treatment as a pregnant woman for your delivery, if you are a foreigner and you're under the age of 21, certain school-based services, as well as certain services through the disabilities education program. If you've got any types of benefits like the ones I just mentioned, then it doesn't affect you. Who does this new rule apply to? It applies to, again, anybody who's not a US citizen. That includes foreigners abroad that want to come to the United States and are applying for a visa, foreigners abroad who are applying for a green card, foreigners in the United States who are applying for a green card, and it may affect you down the line when you are applying for naturalization. There are, however, some people who are excluded from the group, and if you've received a public benefit and you're under this group, then you will not be penalized. That includes victims of human trafficking, victims of violence who are applying for a U visa, victims of domestic violence, special immigrant, juvenile immigrants, also asylum seekers, and those who are refugees. Under the new Totality of the Circumstances approach, immigration is going to consider factors and see, do you have more negative factors or do you have more positive factors? And if you've got more negative factors, they're more than likely going to consider that you are a public charge. Some of the factors include the foreigner's health, their family status, their assets, their financial resources, their education, what type of immigration benefit they're applying for. And also, if someone is applying for you and you have a petitioner, they're going to consider that person's affidavit of support. Before the change in this law, if you were applying for a green card, if your petitioner was your spouse or your parent, or you're a child who's now an adult, Homeland Security would only consider that person's income and their taxes. They weren't worried about that list of factors that I just mentioned. But moving forward and starting in October when they implement this new law with these new changes, they're not only going to consider that, they need to consider everything. So there is a possibility that even if your petitioner makes enough income to actually petition for you and that you've never received any public benefit, if you have more negative factors in your case, it's possible that they could deem you a public charge. And it's really important that you work with an attorney. in this case. You're not an attorney. You don't need to understand this law to the full extent because it's complex, and I only covered a few points. I can go on and on about this new change, and we don't expect you to understand it. You just need to know that it's important that you disclose this information to the attorney that you're working with so that you can have a plan and some type of information that you can communicate to the officer as to why you should not be deemed a public charge and maybe why the benefit that you receive doesn't qualify. Because if you don't have a good attorney who really knows immigration law and who understands this new change, and maybe you don't explain these things in your application, you could be denied, and there you've wasted time, you've wasted money. So find someone that you trust, that you believe has your best interests at the front of the case and is willing to do everything necessary to protect you so that you don't send an application to immigration and risk getting denied solely based on the public charge, which can potentially you can overcome before you file.